I'm very much afraid that we are going to end up sacrificing some of our civil liberties. I don't think most Americans have noticed that, but it is almost inevitable. What we should remember before we get full of gloom and doom is that we are historically among the most free societies on earth. You can know that just by looking at, if I was to say something truly horrendous right now, if I was to say that the Holocaust never happened, and that 6 million Jews were not killed, you all would lose respect for me. Some of you would leave to show that you disagreed with that horrendous abuse of history. But I would not go to prison. I would not face a fine. In France and in Germany and in some of other countries that we think of as very democratic countries, that is against the law. It's always a treat to see some stupid American Nazi go to Germany and give a pro-Nazi speech and then end up fined. We don't fine David Duke here, but when his ilk go there, they do get fined. So we have a broader understanding of freedom of speech. We also have these things like we don't trust the government necessarily to defend us. So we have a very loose gun law. And again, from a European perspective, that's a strange view. We don't trust the government to take care of our health care. In part, that's just a lack of trust in government's ability to do things well. We want to provide for ourselves. So we are a very free country. We're a very free country in the way you're prosecuted for crimes. We allow people a right to remain silent that's quite broad, much broader than most other countries. Yet our record on civil liberties is far from perfect, and we can leave aside race for a moment, but of course that is our greatest violation of civil rights in the history of the country. But I'm going to talk today about a court that you probably have never heard of, maybe certainly not before 9/11, but maybe not since, and that is the FISA Court, the Foreign Intelligence and Surveillance Act Court, or the FISA Court. What is it? 7 federal judges, federal district judges, that are appointed by the Chief Justice to be members of this court. They come alone to Washington, and they sit on the 6th floor of the Justice Department, and they have sat there since 1978. And the Justice Department comes to them with requests for warrants. These are different warrants than what local police prosecutors deal with. These are warrants about suspected agents of foreign powers. And they look at what the FBI or the Justice Department wants to do, and what they want to do is wiretap or bug a person. So break into a home, plant listening devices in it, or wiretap a phone line. And they decide if the government's request is legitimate. They don't have to meet the same standards of probable cause. So it's not it's not like a criminal warrant. There have been over 10,000 applications to this court before 9/11. Do you know how many were turned down? 1. And that was one where the government said, we didn't need this, please turn this one down. And the court said, okay. So this watchdog on our liberty has more than 10,000 times the government says, can we wiretap this person? Every single time the court says yes. Now, why did we set up this court? What was the purpose of having this secret court? And it's not, I mean, it's in the law. I mean, the Congress that passed it was certainly out in the open about what they were doing. We passed it in response to something called the Church Committee. The Church Committee was an investigation led by a liberal Democrat from Idaho, Frank Church, and I imagine Congressman Frey knows him because he knew everybody.
We weren't close.
He was a little difficult guy. Actually, his grandson was a student of mine out in Kalamazoo College, and boy, he was a loose cannon. Am I on television? Damn it. They probably don't get this signal. He was a nice guy. Speaking of nothing, you really should have been at lunch with the congressman, because that's when, the symposium has gone very well and it's been very interesting, but to really learn about politics, I think next year, Congressman Frey should televise the lunch. And okay, back to my lecture. Are we still here? Okay, so why do we have this court? Well, the Church Committee went through and they found out that the FBI, the CIA, and the NSA had been doing a number of things that many Americans were shocked at, that were not done with any judicial supervision. Let me just give you a couple examples. The FBI had a program called COINTELPRO, which was an attempt to infiltrate domestic political groups to prevent them from overthrowing the government. Some of the activities that they did was to infiltrate the Black Panthers, and their infiltrators would encourage dissension, encourage Panthers to think that other Panthers were killing them, to cause a decline in the effectiveness of the Panthers and an increase in the violence among the Panthers. FBI agents were also involved in bugging Martin Luther King's hotel room, catching him having sex with white women, and then sending tapes of those sex encounters to him and saying, "We are going to release these to the media. You should kill yourself now." That's our government doing that, a part of our government, which is why I think that the people who are trying to remove J. Edgar Hoover's name from the FBI building have a very good point. The CIA had a program called Chaos from 67 to 74. They were monitoring domestic groups of dissidents, hippies, yippies, blacks, others, to see if they had foreign contacts, because LBJ and then later Nixon was convinced that if all these people hated America, they must have foreign contacts. And the more the CIA Chaos program infiltrated and found out that they didn't, the more the Nixon administration would say, well, keep looking because we're sure it's there. So they'd expand the domestic surveillance. They also monitored Americans' activities overseas. So the CIA was spying on Americans abroad. And the NSA had these two programs called Shamrock and Minaret. Shamrock was one where they monitored every telegraphic communication to and from America with no notification. And then Minaret was that watch lists were developed of suspicious Americans, and then the NSA, our national security agency, was monitoring the activities of Americans here and abroad. The Church Committee led to a lot of important legislation that limited the ability of the intelligence agencies to monitor domestic activities, and it built a wall between domestic criminal activities and foreign intelligence surveillance so that we wouldn't have this commingling. And the idea of the FISA Court was this court would act as a watchdog. So you have to convince someone from another branch, a federal judge, before you can get this domestic permission. The idea was there was a conflict. Some people wanted to just apply the regular Fourth Amendment to monitoring foreign intelligence, that, you know, you need to have probable cause and you should have to go to a regular judge and it should all be done in the regular way. Other people said, no, foreign intelligence and spying is a big deal. It's a different deal than domestic criminal protection, and we don't need judicial supervision. So the court was a compromise. I think we can say that if more than 10,000 applications were made and none turned down, that there is a problem with the watchdog. It may be on the way to becoming a lapdog. But leaving even that aside, secrecy remains a problem. All that Congress knows about these warrants of wiretapping and bugging is that the number that have been granted each year. That's all they know. The judges admonish the FBI each time they grant the warrant to make sure that the intrusion on innocent people's privacy is minimal. But who is to know if it is or is not? The vast majority of these thousands of warrants never result in a criminal prosecution. So some of the people in this room may have been monitored. That probably doesn't bother you right now. Let me tell you a story and we'll see if it does. You rent a room to a Libyan student, okay? Unbeknownst to you, this Libyan student is the subject of a secret FISA warrant granted by a federal judge to the FBI. Under that warrant, federal agents are allowed to break into your house, plant listening devices there, and monitor your telephone conversations. This can go on now, thanks to the Patriot Act, for well over a year. Now, let us suppose that this Libyan student is not an agent of the Libyan government or al-Qaeda, but merely a sympathizer with the Palestinian cause who's broken no law. Then the agents will break into your house again, take the listening devices out, and you will never know that every phone conversation that you made, if you share a line with this person, and intimate moments that took place in your house were listened to by federal agents. If you never know your privacy was violated, does it matter? What you don't know can't hurt you? Well, up until 9/11, that was the law, and what shielded this from further abuse was there was that strong line I mentioned before between domestic or surveillance of foreign intelligence and domestic criminal prosecution. So that theory was, if the Libyan student's line was shared with yours and you mentioned that you had a penchant for consuming a certain herb, that the FBI agents listening to that would not pass that on to the local police authorities, that there was this wall so that they wouldn't use what they got with a weak warrant, you know, that very weak, flexible warrant application. They wouldn't use it for criminal prosecution. Well, let me tell you another story. If I've made you a little bit antsy about your personal privacy, I know some of you are going to go home and look for bugs in the wall. Don't get paranoid. 10,000 warrants in a nation this big is probably not your house. Well, here's another story. Zacharias Moussaoui, a guy studying flight training. Only he didn't want to learn to take off, and he wasn't really interested in learning how to land. He just wanted to learn how to fly. He became suspicious due to a tip. They arrested him on a visa violation, and the FBI agent said, you know, we want to search his computer. We want to search his belongings. And they asked for permission from FBI headquarters and the Justice Department to apply for a FISA warrant. The FBI and the Justice Department refused the request from the Minnesota office. They said there isn't enough evidence of a connection here. The warrant will get turned down. So in a sense, that lapdog I portrayed the FISA Court as, maybe they really were a watchdog in the sense that had this been 1967, Hoover would have said, great, let's break into this guy's computer, if they had personal computers. And we would have gone forward. So now maybe the system of monitoring actually does limit the government's ability to bug us or to search us. Problem. Zacharias Moussaoui was connected to al-Qaeda. He was at least a peripheral member of the conspiracy that led to 9/11. We caught him in August of 2001. And we chose not to investigate because we didn't think, we kept him in prison, we just sort of were waiting to find out more. We were investigating with French intelligence. On 9/11, it became clear there was enough evidence to investigate the computer of a man who studied flight school but didn't want to know how to land. And when they got into his computer, they found evidence that might have, and I emphasize might have led them to stop 9/11, saving 3,000 people's lives. So this is the balance between the privilege that Americans have in their privacy, the right that they have in their privacy, and our need for security. There's also that problem of the two, that separation between domestic and foreign intelligence surveillance. Mohammed Atta, another one of the conspirators, was caught for driving without a valid license April 2001. And the communication between the foreign intelligence surveillance agencies and local police was very poor. Another hijacker was caught just 2 days before September 11th, speeding in Maryland. Had we known that he was on a watch list, everything might have been stopped. Well, this was the situation of the law at the time of 9/11. Many people would look at this situation and say the government was going too far in protecting our civil liberties at the expense of our security. Other Americans look at the same facts before 9/11 and say the government wasn't doing enough to protect our civil liberties. But the key point is no one really cared that much. Right? We settled with the 78 compromise of this court, and how many people in this room had heard of the FISA Court before September 11th? Raise your hands. Okay, one gentleman in the back. Are you an ACLU member, sir? Okay. So with one exception, a brave member of my own discipline, we really, as Americans, we didn't think about this court. I don't think we thought about the balancing of the civil liberties, and we were too busy with our own lives. Now, 9/11 presented a real change in the goal of the FBI and the Justice Department. And you can look at a great book out by Stephen Brill called After, that just came out this weekend. And it's a fabulous, fabulous book. And he talks about the change that Ashcroft went through. The whole theory of justice changed. Their goal used to be catch people who committed crimes and punish them. Now the goal was stop them before they kill again. Right? Stop them before terror can visit our shores again. This was a very important change for our civil liberties, because what is the great protector of our civil liberties if the government, say, bugs me illegally and finds out that I broke the law? Well, the great protection of my civil liberties is the exclusionary rule. If the government breaks the law to get evidence against me, that evidence is not admissible in any court. And that has been the great check on government abuses. They don't punish the guy who violates my civil liberties most of the time. The punishment is, I get off free. You can't introduce that evidence into court. Well, if the goal of the government is no longer to try me or prosecute me, that check on the government's willingness to violate my civil liberties is much weakened. But under this new goal of stopping terror before it happens, Ashcroft launched the roundup of suspicious people who might have links to al-Qaeda. There were 3 groups of people in this. They were all Muslim Arabs, but there were 3, actually they weren't all Arabs, they were all Muslims. The first group, if you had any connection to the hijackers at all, even the most peripheral, if you went to the DMV on the same day that they did with their bad papers, you were questioned and in many cases detained. If you were an Arab or Muslim and you came up under a state and local investigation, then they asked the state and local authorities to detain you. And sometimes it was just names alone. They actually had cases where local police were going through the phone book looking for people of Arab names and then questioning them. Now, once they got people under questioning or under detention, they wanted to apply maximum pressure. If they were non-citizens, they looked for minor visa violations. Do we have any non-citizens here willing to acknowledge the non-citizenship? It is very easy to violate a visa. Visa requirements are very strict, and they're also poorly enforced. So, if you were to sub for a buddy at the sub shop, right, he said, could you cover my shift? And you say yes, and you accept money for that work, most of the time you violated your visa. So it's really, really easy to violate the terms of a visa, and the INS, that wonderful organization, had done a very poor job of enforcing it, so many people were in violation. Now, the beauty of getting someone under an INS violation, it's civil, not criminal. You're not guaranteed a lawyer, and it can be held in secret, as opposed to a criminal trial. So the government really liked it if they could get someone on a minor visa violation that no one had ever been imprisoned for. Here's a case of Siad Jafri from Pakistan, age 34. He was in a dispute with his landlord a week after September 11th. And his landlord said, I'm going to call the FBI on you. And he did. And turns out he'd worked illegally at a gas station. So his landlord's mad at him. Landlord calls local police. Local police call INS. INS investigates. He violated his visa. He has no connection with September 11th whatsoever. He was in solitary confinement for 6 months for a visa violation. He alleged brutal treatment. He had no access to an attorney. Now, I don't know if it's true, the brutal treatment. The government has refused to comment on his case. But again, the government wasn't worried about breaking the rules of police procedure because they never were going to try Mr. Jafri in a court of law. They just wanted to apply maximum pressure to see if he knew anything. And they kept saying, we'll let you out if you tell us everything you know. He didn't know anything. If there were no visa violations, if the person was a U.S. citizen, then they would try and get him on minor offenses that people normally wouldn't be held for, such as lying to a federal officer, a bad checks case that would normally be handled with a plea bargain, and they'd hold them for as long as possible, threaten them with the maximum consequences if they didn't cooperate. But what do you do with someone who is not in violation of any law and is not an immigrant or hasn't violated their visa? Well, there's a new way of practicing law enforcement in our country since 9/11, and it is a radical shift in a little-used tactic called the material witness program. Now, material witnesses are people traditionally in like a drug case where someone is a witness, but we know they're going to flee because they really won't want to testify for fear that they'll be killed by the drug lord. So they hold this person until they testify at the trial, and then they let him go. Well, this rarely used tactic became very, very common in the weeks after 9/11 because Ashcroft and his team, Michael Chertoff and Viet Din, figured that, one, material witnesses don't get access to lawyers, right? They're not charged with any crime. so they don't have to get an access to a lawyer. So their family won't know where they are. Their lawyer, the media is not given how many people are held under the material witness program, and you hold them until they get to testify. Well, if there's never a trial, how long is that? And because a material witness is automatically linked to a grand jury, like it's typical that you'd have a grand jury proceedings, there was an ongoing grand jury that was kept going in New York. And grand jury proceedings are secret. So you had, we don't know how many, but at least 500, estimates range up to 3,000, people arrested all across the country and never charged with anything, entirely up to the executive branch when they get out of prison. Right? The executive branch can finally decide, okay, we are sorry, you're out of jail. Do we have a problem with this? Let's give Ashcroft his due. There have been no more 9/11s. On 9/12, that was the mission that was handed to John Ashcroft, and he has done his job. We are grateful, or we should be grateful, in the sense that nothing else has happened. Trust me, there are people in the world today, and there's a lot more now than there were 2 months ago, who want to do tremendous damage to this country. And without aggressive law enforcement, they will do so. It is a balance. There was a real threat. Into this mix, after the roundup had begun, comes the Patriot Act. I know that you heard it mentioned, or if you were at the morning session, you heard. But just for the record, I love the acronym. I'm sure someone got some money for this at the Justice Department. It's the USA Patriot Act, which stands for Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism. It's not just a government program, it's a spelling bee. What the Patriot Act did was that it lowered the standards for an intelligence warrant under the FISA. It increases the length of time a bugging and wiretapping warrant could be issued. It increased the size of the FISA Court, and it broke down that wall between sharing information between the criminal and the foreign intelligence surveillance, so that if now you were renting a room to a Libyan and the government found out something about you, they could share it with the local authorities. It had a number of other provisions. It allowed the government to search phone, library, and internet records with no notification to the patron. So our library, you could just go up to a library and say, we want to know every book this person has checked out. We want to know every website this person visited when they were at your library. It also, after the, it had the Keller Amendment, which we heard this morning, that there was that link between the FBI watch list and the FAA passenger list. In all these ways, the Patriot Act limited our freedom, but you know, it could have been a lot worse. Ashcroft wanted to suspend habeas corpus entirely. Habeas corpus is your ability to force the government to show the reason why you've been arrested. And that was a proposal. Ashcroft now says he can't really remember if that was part of it. But James Sensenbrenner from Congress, a Republican, says it was. And the guy who wrote it, Viet Dinh, won't be interviewed. But it was part of the proposal. Enough people saw it when it was out there. But Congress said, okay, we'll go this far. But just as, which congressman was it? It was actually Keller himself who said this morning, that there is this hold that the Congress will not pass everything the Justice Department wants. So it could have been worse. But today we are in an America where we've lost the absolute privilege to lawyer-client privacy, so that in some cases, if you are in prison and you're talking to a lawyer, that the government asserts a right to listen in. We have people arrested. We don't know who they are. We don't know where they are held. We don't know what they're charged with or if they're charged with anything. They don't know who their attorney is. And attorneys, when known, have been placed under gag rules so they can't talk to the media about the case. And what has been the combined response of the American public to this? Good. We support this. Poll after poll after poll. Not only do we support this in polls, but we support this by our non-action, by our non-reaction. When the Patriot Act passed, it passed overwhelmingly. I was on a plane with Paul Wellstone, who was a real strong defender of civil libertarians, or civil liberties, and he said that he was going to vote for it. because it had a sunshine component sunset provision. A sunset provision says after 4 years, this law expires, and Congress gets to vote on it again if they don't like what's been done. So that was his reason for voting for it. It would not surprise our founders to discover that that was our response to 9/11. It would not amaze anyone who knows anything about public opinion in times of crises. Let me give you a quote, kind of a long one, from the Federalist Papers. The Federalist Papers, actually I was talking to Congressman Frey about this, and he feels that not enough people know what the hell the Federalist Papers are. He didn't use the H word, I just put that in his mouth. But that people don't have, so I do want to include a little. The Federalist Papers were documents written to explain why we should pass the Constitution. They're written by Alexander Hamilton, James Madison, and the forgotten third, John Jay. So this is from the 8th Federalist. This is by Alexander Hamilton. Safety from external danger is the most powerful director of national conduct. Even the ardent love of liberty will, after a time, give way to its dictates. The violent destruction of life and property incident to war, the continual effort and alarm attendant on a state of continual danger, will compel nations the most attached to liberty to resort for repose and security to institutions which have a tendency to destroy their civil and political rights. To be more safe, they at length become willing to run the risk of being less free, unavoidably subjected to frequent infringements on their rights which serve to weaken their sense of those rights. By degrees, the people are brought to consider the soldiery not only their protectors, but as their superiors. Our founders knew that under the threat to our own safety and security, we would give up important liberties and we would not even notice it. And once again, the brilliance and the foresight of our founders are shown in that they anticipated that if presented with this challenge, we would give up our liberties. The Ben Franklin quote is more popular, the one that he would give up his liberties in return for security deserves neither, right? But I think the Hamilton quote, while longer, is much more accurate, that we will give up our liberties and we will get security. We have been safer. It is a trade-off, but we need to make the choice more openly. If we wish for our civil liberties to preserve what can be preserved under this threat of security, we have to be more open about what we are giving up. More people should know about what's going on so that they can knowingly consent to the actions of our government. There is a new Patriot Act being worked on in Washington that will further expand the Justice Department's powers. That should be a subject of debate. I hope it is a subject of debate at this conference and at later conferences. I'd like to leave you with a couple ways to think about civil liberties in a crisis. There's two ways to really analyze these. One is that terrorism is a disease, a terrible disease. It is a real threat to our safety, and no one who lived in Arlington and was there that day when the Pentagon was hit can say that there wasn't a real threat. It is a terrible disease, and sometimes terrible diseases can only be fought with very, very strong medicine. Right? So that the idea is that our loss of civil liberties that we've experienced since 9/11 is like cancer medication that makes you sick while making you better. Another way, however, is that these civil liberties restrictions are a slippery slope, that we are in the process of just the beginning of the loss of our liberties, along with the clenching and the shortening of the allowable political discourse that I mentioned this morning. We're going to lose other liberties that are more obvious. We've also lost liberties that the government didn't take away from us. It's not the government's fault that a few days after 9/11, a woman was getting on Amtrak, and because all the planes were shut down, and she said, "I just don't feel safe. No one searched my bag before I got on the train." We've lost that liberty that we didn't know we had, and it's not John Ashcroft's fault that it's taken away. The liberty of feeling safe without being searched. We just heard someone in this prior session talked about surveillance cameras. What a statement that Americans feel safer on camera than off. We had the sniper up in D.C. During the sniper investigation, they just printed something in the paper that blew my mind. It said the average Washington, D.C. resident was on camera 7 to 8 times each day. So that, and the cameras haven't even begun to approach the level of camera activity in Amsterdam or London, so that we're always having this unseen eye. And that could just be the start. Because the key to this war on terror and to our loss of liberty is, how long will this war last? How will we know when we've won it? A young man asked this question of the congressman at the end there, and I think that the last question he asked was the best. How will we know when we've won? All we know is that Ashcroft is telling us it will be a very long war, and he's right. We will not get out of this war anytime soon, so if it's a disease, it's going to be with us for an awful long time. How large is the threat of terrorism? I'm no expert on the threat of terrorism. That's not why they brought me down here. But let me say, in my judgment, it is large and growing larger all the time. That we can kill many, many people who say they hate America. In so doing, we may make many more people hate America. And I don't know that Israel has successfully figured out a way, with their tremendous military superiority over the Palestinians, to come up with a way to stop terror. And they have used far more brutal means than we have yet to use, and they are facing worse and worse problems. I think that the prospect for our civil liberties in the short term and the medium term is therefore not good. I think that we have to be open about that the only justification for these sacrifices is our security, and that the last liberty we should give up is open debate. That each time they come to us and they say, you must give up this freedom, and you must give up this privacy, and you must give up this liberty, then we have to have them justify it. There should be a full and open debate, and that we should not call those who defend our civil liberties traitors or abettors of terror, as was done in the first few months after 9/11. Even if you disagree, if someone else is going to draw that line somewhere else, that person is still an American. That person is still a treasurer of civil liberties. And so as we give up these liberties, as we already have, we need to have a more open and honest debate. We also need to have everybody give up their cherished liberties. In other words, if we're going to give them up on the left, let's give them up on the right. I was lecturing at Southwest Missouri State on this book, and it was a smaller class, and I was talking about how we're giving up these racial profiling freedoms and we're giving up these privacy freedoms, and a young man interrupted me, and I love it when people interrupt me, so please do so. And he said, well, we can trust the government. We can trust the government to do the right thing. It was in Missouri. They trust John Ashcroft in Missouri. They know him, and they say, he's after. We have to this is a time when you have to put your trust in the government. And we talked about that for a little bit, and then I got onto the issue of the Second Amendment. And the same young man raised his hand and said, but we can't trust the government with the knowledge of who has a gun, and we can't trust the government with licensing and all this. And I said, well, wait a minute, wasn't this our great friend, the government, back a moment ago when we were talking about speech and privacy? So John Ashcroft is going to be going through library records, not him personally, he has people to do this for him, but the one rule that he's kept sacred is the Second Amendment. We have a list of people who purchased guns after the Brady Bill, and they have resolutely refused to cross-check that with the watch list. The most simple activity, because that would violate the privacy of gun owners' rights. Well, if everybody else has to give up some privacy, I think the NRA's got to bite the bullet, right? But at least let's have an open, the NRA has to bite the bullet. I'm funny and I didn't even mean to be. With that said, I would like to end with the plea that we do debate these issues in a full and open way, because that is our most treasured civil liberty, and I would entertain questions at this time. Thank you.